Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. I'm here with Ann Lipton, a law professor at Tulane in New Orleans, who teaches and researches securities and business law. She holds up, of course, the legal end of our little podcast here.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Thank you. Let's talk today about the purpose of a corporation. Seems a little abstract and existential, but we can get quite practical pretty quickly and apply that to an interesting bit of actually litigation over that purpose involving Meta, which is also known, of course, as Facebook.
Yeah, I'm just going to call it Facebook. I'm sorry, I can't call it Meta. But
Very
yeah,
well. I'm with you.
Let's also cover an interesting twist on corporate purpose and shareholder proposals, where activists find themselves as defendants in litigation over these proposals.
Yes, companies suing shareholders over this. But before we get to that, let's talk a little more broadly about corporate purpose, because it actually has gotten lots of attention over the decades, but it's also gotten attention quite recently. And there's so many different dimensions to this. But let's kind of ground it in eventually getting to this case involving, I was going to say Meta, but let's call it Facebook.
Yes, please.
So why don't we talk for a minute about corporate purpose kind of broadly cast, and then we can sort of narrow it down. How's that?
Okay. Sure. So, I mean, the debate over corporate purposes has been raging for literally over 100 years. And the debate is, what is the legal obligation of a corporate board? Is the obligation to run the company just to benefit the stockholders, to maximize profits? That's what we call shareholder primacy, the name of our podcast. It's the idea.
I knew this was going to come back up at some point.
Exactly. That's why we called it that. So this is the idea that the job of a corporate manager is to maximize wealth for shareholders. Is that what corporate boards are supposed to do? Is shareholder primacy the rule? Or is the rule that corporate boards should act to benefit the corporation as a whole? And when I say the corporation as a whole, I mean all the different contributors to corporate functioning, not just the stockholders who supply capital, but also the employees, the customers, the vendors, the surrounding communities. When boards make decisions, are they obligated to only consider stockholder interests, or may they consider the interests of the corporation writ large, meaning all these lives that the corporation touches?
And we can call the rest of those people stakeholders.
We will call them stakeholders. Exactly. That's what they're called.
Shareholders,
stakeholders.
Got it. Okay, go ahead.
I want to be clear. There's no question that in many ways, the only way to benefit stockholders is to also benefit these other constituencies, like consumers. If you make a crap product, no one's going to buy it. There won't be profits for your stockholders. But I'm not talking about that. I'm talking about whether corporate managers are permitted or even have an obligation to try to benefit these stakeholders, even if there's no corresponding benefit to stockholders, even if you end up reducing profits in some way. Now, the reasons for this fight are obvious. Corporations are very powerful. They amass the resources of thousands or millions of people, and that means corporations can inflict tremendous harm on people, or they can confer tremendous benefits. So throughout modern history, there's been this argument that corporate managers have an obligation to use that power responsibly to ensure that profit-seeking corporations don't inflict harms on other groups. But others have argued, no, the job of a corporate manager is to earn a financial return to shareholders.
Make money. That's why we set up this thing in the first place.
Exactly. Right. They should seek to maximize profits however they can do so, or at least however they can do so without breaking the law. And you can understand there are arguments on both sides. So on the one hand, we know that corporations can exploit people. They can underpay employees. They can make dangerous products. And the law won't always be effective in forcing them to behave responsibly.
Right.
But if we tell corporate managers, your job isn't to maximize profits, your job is to benefit society, well, we may not like how corporate managers interpret that instruction, like Elon Musk or Henry Ford, who was famously anti-Semitic. Are these the people we trust to take the resources of the corporation and use them to benefit society? I mean, that's the last thing I want Elon Musk to do, because I'm pretty sure I wouldn't agree with his judgments about who should be sacrificed.
Or his choices, exactly, right.
Right now. So if we don't want America's CEOs to decide the moral direction of our country, we might tell them, stay in your lane.
Right,
your job is
just focus. If you focus on making money, and this as a civic matter, we'll take care of what other things that you have to
Exactly.
do. So this is we're still debating this. I mean, after decades and a
100
century
years,
or more?
over a
Okay.
century. So
why hasn't it been settled?
because
I guess.
courts don't interfere with most managerial decisions, no matter who they benefit. Suppose managers decide to give their employees a raise. That benefits the employee. Great. But it may also benefit shareholders because the employee works harder, there's less turnover, there's less labor unrest.
Right.
And no court's going to go in and say to the board, wait, are you sure a raise was necessary? Did you give the employee the absolute least amount you could give them?
Did you negotiate this as absolutely hard as you could?
Exactly, which means
Did you
managers
leave
have
any money on the table?
So managers have a lot of discretion to decide whose interests they should prioritize, shareholders or other groups. And corporate managers love to couch their decisions in flowery talk. So they'll say things like, at the Acme Company, customers are our first priority. That's just good business.
Right, exactly. Right.
So historically, there wasn't a lot of law that said corporate managers have a legal duty to maximize shareholder wealth. It just didn't come up that much. That said, if we're talking about Delaware, where most publicly traded corporations are organized, in recent years, Delaware's actually become much more explicit about articulating, yes, corporate boards have a duty to maximize shareholder wealth. They can be generous with other groups, they can compensate employees well, they can protect the environment, but only to the extent these efforts benefit shareholders. Delaware's gotten really explicit. Employees and customers are only valuable instrumentally as tools to benefit the stockholders.
The point of the corporation under Delaware, this is a legal point.
As a legal matter, but
as a
Delaware,
matter of duty.
Yes, but Delaware's not the only jurisdiction. I mean, I know we forget that sometimes, but really, there are other states.
There's other
and
states.
Lots of states have explicitly adopted laws that say boards only need to benefit the corporation as a whole, and it's fine if they want to prioritize workers over profits.
Okay. Oh, interesting. All right. So the trend seems to be, as a broad principle, that the shareholders, the owners, whatever we mean by owners, we can spend another podcast talking about what we own. Me as a shareholder, when I own companies, what exactly I own, and do I get residual rights? That's a whole different podcast. We'll figure a different episode for that. But anyway, the shareholders kind of sort of have priority over stakeholders, as we've said, at least as a matter of duty and law. Right.
Well,
okay,
in Delaware, yes, not necessarily in other states,
Right,
but
fine.
as a practical matter, I think we can look at the world, if we look at what we observe in the world, and we definitely see that shareholders are getting prioritized. And that's because of you. It's because of you, Mike. It's you.
Got it.
As we talked about last time.
Guilty as charged.
Exactly. The reality is only shareholders get to vote for corporate directors. And activists like you will make sure that corporate directors focus on improving returns. You mentioned this just last week.
Exactly right. All right. So let's apply this set of principles to the hundreds of ESG proposals that we see each year. And we know that there are many different shareholders. We've seen this. Then there's almost 1,000 proposals, precatory proposals were submitted at U.S. public companies so far since about September or October of 23.
Yeah, and that's not new. I mean, this has been going on since 1951, actually, when a proposal asked Greyhound
Well, it hasn't been 1,000. There weren't 1,000 of them back then. The number has increased dramatically.
Yeah, the numbers increased over time. It's gotten routinized. But yeah, so as I said, there are good reasons to be concerned that corporations place too much emphasis on shareholder wealth, and maybe they harm other groups in the process. But, as we said, we don't necessarily want Elon Musk or Mark Zuckerberg or whoever leads Boeing today to make judgments about what's best for society, because why would their judgment be better than anyone else's? So, what's the alternative? The alternative is maybe shareholders collectively can decide to benefit other groups. After all, if the job of corporate boards is benefit shareholders, if we believe in shareholder primacy, the next logical step is that shareholders can decide they want something other than pure profits. Maybe shareholders want clean air and water and cheaper products and decent wages. And shareholders, they live on this planet and they buy products and they earn wages. And maybe they'd rather firms improve their lives in these other areas rather than simply maximize prices. And since it's not corporate boards making social decisions, it's the great mass of America's shareholders making the decisions, maybe that's more democratically legitimate. So we have these ESG movement asking shareholders to tell corporate managers to be more socially responsible.
Right. So, and again, without talking about one or another individual proposal or types of proposals, we're sort of talking about ESG proposals sort of as a class of effort, and so and again they all because that's how they have to work. They they get to be kind of specific, with the exception of one that we're about to discuss, or one matter that we're about to discuss. So as an aside, what's sort of been the impact? Is of these ESG proposals? Is it realistic to think that it's worked? What's the experience been?
I mean, some of them do pass, but here's the issue. The problem is that, as I explained it as a theoretical matter, shareholders live and eat and breathe on this planet, and they work, and they might want to vote for something other than pure profit maximization in their investments. But the problem is that that's actually not who the shareholders are at all, because the shareholders are actually giant institutions.
Right.
We've gotten rid of the retail shareholders today. Like 80% of the shareholder base is institutional.
It depends on the stock, but yeah.
Exactly.
Right.
Yeah, it depends on the stock, but that's most of the American publicly traded stocks. So they're BlackRock and they're Vanguard and they're State Street. They're America's pension funds. They have legal duties, or at least extreme market incentives, to maximize wealth for their beneficiaries. So they're not going to get caught up in a Save the Whales campaign. So most of the time, ESG proponents try to find ways to argue that these socially responsible proposals are in fact wealth maximizing. Yes, you're benefiting society by saving the whales, but also this will earn you the goodwill of your customers. But that just puts us back where we started. Corporate managers have already plenty of incentives to maximize shareholder wealth. And if saving the whales or saving the planet will do that, they will do it. They don't need a shareholder vote to tell them so. So lately, in academic thinking, there's been a new twist, and this gets us towards this new case. So the twist is, look, these big institutional investors, they're diversified. They don't just invest in one company. Pension funds and mutual funds are even legally required to diversify. That means they aren't interested in maximizing wealth at one company. They want to maximize wealth across their entire portfolio. And it may be that some companies behave so badly socially that they actually damage other parts of the economy. And these large diversified shareholders may prefer that these companies behave better, even if it costs them profits, because the portfolio overall will benefit. So climate change, most obvious example. You may own shares of Exxon, and you may profit from their shares. But you might also own beachfront property in Florida, or North Carolina, or restaurants and hotels in New Orleans. And you might think,
a REIT that
owns all those kinds of things.
Land.
Exactly.
Right, exactly.
And you might think it's better for you overall if Exxon reduces production and sacrifices profits, if that means that your New Orleans restaurant that's owned by the REIT isn't washed away in the next hurricane. You might prefer...
So you're going to have this portfolio view, and the idea would be that if you're one of the big three or some other fund or some other diversified shareholder, that you will vote on the interest of your portfolio, or should vote based on the interest of your portfolio, not based on what's good for one or another allocation or one or another stock in the portfolio.
Exactly. And that may mean that you promote profit-reducing measures at particular companies in order to benefit the portfolio overall. Now, this is a controversial proposal, and there are certain problems with that line of thinking, and I'll just outline some of them. First, it may not be easy for institutional investors to figure out exactly what the calculus is for when they prefer to reduce profits to benefit their portfolios. And if they can't figure it out, it's even harder for corporate managers to figure it out, because shareholders don't have direct fine-grained input into managerial decisions. Plus, there's a dark side here, because if I'm a large diversified investor and I own stock in, say, Delta and JetBlue and Southwest and American Airlines and United, you know what I definitely want? I want them to reduce profits by competing less with each other. Sure, Delta, you might increase profits by lowering your prices, but then United will reduce its profits and American will reduce its prices, and everyone will make less money. We, the diversified shareholders, would rather you all just stand pat so you can maximize the value of the industry, and now we've just formed a conspiracy and restraint of trade. So that's probably pretty bad. Another problem is that BlackRock isn't actually one large diversified shareholder. BlackRock's portfolio is divided up among hundreds of mutual funds and separate accounts for various clients, and each client has their own holdings, and some might be perfectly diversified, but some might be, say, weighted towards energy. They don't all have the same interests. So BlackRock can't simply say it's better if Exxon reduces emissions because that protects the New Orleans restaurants. Some individual funds may not have exposure to New Orleans restaurants, and some may be overweighted to Exxon. And BlackRock really needs to tailor its votes to benefit each fund or client, and that means that they don't have as much voting power overall. That said, notwithstanding all these drawbacks, at a very high level, there's some persuasive value to the idea that large investors may, in fact, want corporate policies that benefit the economy overall, and that means maybe reducing some of the worst excesses of individual firms. This is sometimes called the universal owner theory, that large institutions are universal owners. They care about the economy more than any particular firm.
And that then had its most recent culmination in not a shareholder vote, but a lawsuit.
A lawsuit.
Involving, I was going to say Meta, but let's call it Facebook.
Involving Facebook, please.
So
involving Facebook.
What was that? Let's talk quickly about what that lawsuit involved.
Okay, so this is Jim McRitchie. He's a very well-known stockholder activist, and he moved ahead to test this idea legally. So Facebook is incorporated in Delaware, meaning it's subject to Delaware law, and Delaware, as I said, has become very explicit that boards have a fiduciary duty to maximize the wealth of stockholders. So Jim McRitchie sued the board of Facebook and argued that since most stockholders are diversified, the duty of Facebook's board is to maximize diversified stockholder wealth. And he said Facebook's board breached that duty by making a lot of business decisions that created harms throughout the economy, even as they benefited Facebook. What kind of decisions? Decisions to tweak the algorithms in ways that promote user engagement but harm society, promoting divisive and content and misinformation, promoting Instagram content that causes eating disorders, being slow to remove posts that facilitate drug trafficking. So Facebook creates all these societal harms, argued McRitchie, that are very profitable for Facebook but harm these diversified investors by damaging the economy. And he argued that because Facebook's board and its CEO, Mark Zuckerberg, are so heavily invested in Facebook themselves, they're actually conflicted because their interests diverge from the interests of most Facebook stockholders. The Facebook board has a personal financial incentive to maximize Facebook's wealth, when in fact, most Facebook stockholders would rather maximize portfolio wealth. So, breach of fiduciary duty. So this is this extremely novel complaint.
And so they filed the complaint, and it didn't take very long for Delaware to rule on this.
Yeah, no. So this is B.C. Laster's case. He always seems to catch these big theory cases.
But he's fun that way.
He really is. And he, of course, rejected the claim. He held that under Delaware law, the duty to stockholders is only a duty to maximize wealth at that particular firm, not some other firm based on a hypothetical stockholder portfolio. He called it Delaware's single firm model.
Right. Okay. So, and there wasn't really much in the way. I mean, there was a pretty quick argument here. Like I said, there wasn't a real lengthy procedural matter.
No, but it was he dismissed it on the pleadings, but it was a very lengthy, sort of theoretically rich kind of decision.
Right. But they didn't get into a lot of facts about what in fact Facebook did or didn't do.
No.
So what is that? What did his ruling imply for this broad theory of social responsibility for companies? Does that mean this kind of theory of universal ownership is on hold or dead, or what do we think of that?
It's only mostly dead. It's still a little alive. Because McRitchie was the one who argued that boards have a legal duty to maximize diversified wealth. But the academic theory that he was drawing on is subtler. The academic theory is that large institutions have an incentive to encourage portfolio companies to sacrifice profits if it would benefit the economy overall. It doesn't rely on the fiduciary duties of boards. It relies on the raw power of large institutions to make demands and see those demands fulfilled. And if corporate boards do honor the wishes of their shareholders, if they do sacrifice profits at individual firms to benefit the economy, no one can stop them because we're back where we started. Right. No court's going to interfere with a board's judgment to curb carbon emissions or raise employee wages or anything else. Boards can go ahead and take those measures as long as the stockholders don't show them the door.
And so then it comes down to folks, to schmoes like me.
Exactly.
Who then decide with our buy and sell orders or our votes about what a company does. But we've kind of affirmed that the legal duty is not basically the summary here is the legal duty of that board is to the company, not to the economy.
Well, the legal duty of that board is not what's driving the train. Okay, the formal legal duty is to maximize shareholder wealth at that firm. But at the end of the day, it's the power of shareholders that dictates what the corporation actually does.
Got it. Wow. Very fun.
Yeah.
And interesting. All right, let's take a quick break, and we can return to talk about a different take on corporate purpose involving another lawsuit, and this one would be, of course, at ExxonMobil here at Shareholder Primacy.
This is the Free Flow Media Podcast Network, where we cover the who of the business news, because investing isn't a what, it's a who. Check out our other podcast, Business Pants, for fact-based snark covering companies and executives, and the Proxy Countdown, the only podcast that treats company meetings like sporting events. Find them on iTunes, Spotify, or wherever you get your podcasts. Back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin. So let's take a look at a different company and how it handled shareholder proposals that pertain to corporate purpose. And I'm specifically talking about ExxonMobil and its proposal situation recently. So it receives all of these ESG proposals every year. And recently it received proposals from two repeat sponsors, Arjuna Capital and Follow This. Now, Mike, I'm going to start by asking, who are Arjuna Capital and Follow This?
So they are frequent ESG proponents. Arjuna Capital is based here in the U.S. Follow This is based in the Netherlands. And they specialize, as a lot of listeners know, some might not, in mostly climate, but also some social, the E and the S proposals. And they submit dozens and dozens of these proposals at many different companies each year. It's pretty straightforward. We've talked about that before. That's the old 14A8 process, where they've become very skilled and accustomed to navigating that. They write a proposal that seems to make a point at a company where they think a point needs to be made. And they don't, in my understanding, they don't tend to work a lot together on this. They just happen to be kind of intersecting at ExxonMobil on a particular set of climate proposals. And again, ExxonMobil's been on the receiving end of numerous climate proposals to set sort of different kind of goals and to manage their energy producing assets in different ways. Where Arjuna Capital and Follow This just kind of almost drew the wrong lottery ball. Okay. Here in this particular situation.
Okay, so in this situation, what did they do exactly? What were their proposals?
Oh, they had proposals to basically set different kind of climate goals. Okay. For ExxonMobil to by 2040 to reduce your climate emissions in a certain way, or to divest of certain kind of assets, okay. Which gets to a core debate about what kind of business should ExxonMobil be in and so forth. But Arjuna Capital, and like I said, Follow This, we're just basically doing the same thing that they've done for a long time. Just submit a fairly strict or demanding set of climate proposals to a big energy company.
So it's it's Arjuna Capital, by the way. Is that how it's pronounced? I've only seen it written.
Arjuna, I think it's Arjuna.
I've called it I don't know. Okay.
Arjuna,
so
Arjuna
normally
Capital.
When Exxon or any other company gets a proposal like this, what does it do?
Okay, so there's a normal kind of pantomime they go through, where most of the time they're going to seek to not include the proposal and the company proxy. They'll go to the SEC and sort of say, if we exclude this from our proxy material and not let shareholders vote on it, you won't be sore at us. The SEC has become increasingly restrictive about that and insisted that companies include this kind of proposal. We can just debate at another time how the SEC views this, but yeah, go ahead.
They don't insist that the company includes it,
right?
They just say they can't agree that the company is allowed to exclude it.
Exactly, right. So they won't. They basically formally the SEC says yes, we will pursue an enforcement action if you. Well,
they don't promise they're going to pursue an enforcement.
Right.
They just leave it open. They leave the door open.
Yeah, exactly.
So Exxon didn't even bother go to the SEC to see whether to exclude it. What did it do here?
They took a different turn. Now Exxon is famously arrogant about their corporate governance and so forth. You may recall that about 3 or 4 years ago, they were in the middle of a vicious proxy fight with engine number one, where engine number one managed to elect 4 independent directors to the Exxon board. Exxon has just been in the middle of this kind of stuff for a long time. Exxon bypassed completely the SEC's 14A8 no action process. They instead litigated directly and sued in federal court in Texas the 2 shareholders, Aruna and Follow This, and said, we are going to get a judge to say that we can exclude these proposals from our proxy, and there's nothing you can do about it. No SEC.
And I just have to mention, since you mentioned the engine number one thing, they've got these new directors on the board who are elected specifically on a climate change agenda.
Yes,
they're there, but still Exxon sues its shareholders to exclude this proposal.
There's and again, there's only 4 out of, I can't remember how big the Exxon board is.
Yeah, I think 3.
People.
Yeah,
so
I think actually 3.
They're a minority.
Yeah.
So it's possible that those engine number one directors.
Oh, that's an interesting books and records question, isn't it?
Yeah, saying, look, we shouldn't be sharing. So sue shareholders over this or whatever. But obviously, their views did not prevail. So Exxon sued these 2 shareholders to basically say, we're going to get a judge to let us not do this. We're not. Importantly, the SEC, Exxon did not want to rely on the SEC's process. They kind of lost faith, if you will, in their ability to make the case to the SEC that these proposals didn't belong on the corporate agenda, and wanted to basically go around them. Which that was kind of unprecedented. That really hadn't happened very much before. Everyone sues everybody over everything, but this was one of the first times that a company sued its own shareholders about a shareholder proposal for the agenda.
Okay. So how did other Exxon shareholders feel about this? Like all these other shareholders who invested in Exxon, they don't get a chance to vote on the proposal.
They were there were a number of shareholders that were very sore at this. They wanted to be able to vote on this. They wanted to continue to urge ExxonMobil to consider these kind of proposals. And so they started doing stuff like a withhold campaign. So they wanted to not elect certain directors that seemed to be in support of this litigation. Other shareholders, not clear what they thought. There is some sentiment among some shareholders that there's a lot of this ESG stuff and they're getting a little fatigued by having to pick and choose and vote and so forth. But at least there was a vocal minority of shareholders that were not happy with how this worked out. And of course, Aruna and Follow This were completely panicked. They needed to show up in federal court in I think the Southern District of Texas, probably in Houston, to defend this litigation.
Actually, I think it might have been Fort Worth actually, because
Fort Worth, wherever they have to go for this.
Yeah.
So they did not want to spend money on this. So they backed out quickly. Well, they withdrew. What they did is they withdrew their proposals, which you can do. They withdrew their proposals, and the case I think eventually became sort of moot. And eventually, I think it was dismissed.
Yeah, I think Aruna actually had to promise never to file a similar proposal at Exxon again. So it really just departed the field.
Yes, but interestingly, Exxon, was not, they got a lot of shareholders, a lot of these ESG shareholders kind of PO'd at them, and so that they continue to have to deal with that. But Exxon didn't stop there. They included in their proxy statement for 2024 this unbelievable rant, like 3 or 4 pages of defense. And this was not around. Again, the proposals weren't on the proxy. They weren't on the annual meeting agenda. They just had several pages of harsh criticism of shareholder proposals and defense of their own, sort of environmental policies. So Exxon, clearly these shareholders had sort of touched a nerve, and had gotten them sort of, quite annoyed at these proposals and so forth. So Exxon went as far as devoting some real estate in the proxy statement to further critique or further criticism of this whole proposal movement. So I would guess that Exxon's not gonna see very many of these. Now that Exxon's demonstrated this willingness to kind of sue people over this, most shareholders are like Aruna and follow this. They don't want to be in court. They don't want to.
They may not. I mean, it'll be interesting to see because I think this proposal might have been particularly vulnerable, but other ones may not be.
I think that's a good point. That there may be either other proposals that would be a little more widely accepted, or there may be some proponents that are willing to kind of face off. That are willing to.
Except Exxon gets to sue in Texas, where before a sympathetic judge, as they.
I could imagine one or another shareholder that might want to try to take on that challenge. Again, it won't be cheap.
Yeah.
But they may want to try to make it. On the other hand, there are a lot of other ESG proponents that are now starting to walk around wondering. Is there going to be more litigation like this? Now that Exxon has sort of opened the door to suing a shareholder in federal court rather than going to the SEC for this, I'm familiar with other ESG proponents that are a little cautious about some of their proposal practices. At least at some other companies that seem to be similarly stubborn about what goes on their meeting agenda and their proxy materials. So there seems to be this seems to have put a little bit of a chill. Yeah, at least for now.
I will just mention though. I mean, just from a legal perspective, one interesting issue is the venue. So I mean, here's the issue. Exxon is traded internationally. Follow This isn't even an American company. Exxon is incorporated in Delaware, and yet they sued in Texas.
Exxon's in New Jersey.
Oh, it's in New Jersey? Ooh, whoops.
Yeah. That's okay. I mean, the two are similar, but they're only a few miles apart.
But the point is that, but it's sued in a Texas court where they could be very sure that they would draw a Republican judge who was likely to be sympathetic to Exxon and not particularly sympathetic to someone who wants to curb emissions. So that was actually part of the initial skirmish. Can they even sue in Texas as opposed to anywhere else? And the court said they couldn't sue Follow This because Follow This was international. And they could sue Aruna in federal court or Aruna in Texas. But the reason was because Exxon has its headquarters in Texas.
Right.
Now, not every company is going to have that. So it's possible that if another company tried this trick, they wouldn't be able to bring their case in a Texas court, and they might find themselves in a court that is more sympathetic to the proponent. A little more
sympathetic to the ESG. Right, yeah. So a New York-based company that tried this tactic may not try to do it. But again, there's on the one hand, there's lots of public companies in the U.S. that don't want to be viewed as as hostile in this way.
Yeah, I mean, exactly.
Their shareholders.
They might just say it's a precatory proposal. Let them vote. They can vote as many times as they want.
Right. But somehow, Aruna and Follow This, like I said, they kind of got under their skin. But like a bunch of others, maybe there are people at Exxon that just finally it seems to have had enough and wanted to take this a step further rather than just leaving it up to shareholders to decide. And there's all sorts of rules. If the proposals don't do well enough year after year, they can't
keep briefs. Yeah, and that was an objection this time.
Yeah, exactly. Anyway, so that's another flavor, another take on this kind of corporate purpose in these proposals, which was really fascinating. But there could be more of this in later this year and into next. So we'll see.
Okay. All right. Mike, let's wrap up there, and there's more we'll cover next time.
Good idea. Let's do that. Ann, it's been terrific talking about all this. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is the Michael M. Fleischman, professor in business law and entrepreneurship at Tulane Law School and an affiliate of Tulane's Murphy Institute. You can find me, Mike, at theactivistinvestor.com. You can find Ann at law.tulane.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening, and we'll talk again